everyone, for our second night this week of Land Trust Law School. This is our advanced topics Q&A. So I hope for those of you that are coming back from Tuesday that you brought your questions, and hopefully we sparked some ideas for you. Again, this is a relatively small group. I can see you all on one screen, which is always a great sign. I love when I can see everyone together. So we can keep things, I think, relatively low key in terms of how we ask questions. Feel free to mute and unmute yourself to ask questions aloud, or if you would prefer to type them in the chat, you can do that and I'll read them aloud as well. If things start to we kind of get some questions stacked up on one another, then I'll ask everyone to use the raise hand function, which you'll find at the bottom of your toolbar. There's a little reactions button. If you click that, there's a button that says raise hand, and that's how we can kind of queue you up for questions. But for now, I think we can keep this relatively loose. And yeah, am I missing anything, Amy, or? All right, we'll jump right in. I hope you all know Linda Francois and Ayla Wastrom Evans here with us to answer your questions. And I'm going to go ahead and pass it right over to you. And yeah, Linda and Ayla, I don't know if you want to do a brief introduction of yourselves or.
Yeah, I'm Linda Francois. I'm an attorney practicing in New Haven, although I go everywhere in the state, and I represent land trusts and landowners and sometimes municipalities in land transactions. And I am the editor of the Model Easement series, of which Ayla is a member of our steering committee. So Ayla, why don't you introduce yourself?
Sure, I'm Ayla Wastrom Evans, an attorney at the Prue Law Group. I work mostly in Willimantic, Connecticut, and Northeastern Connecticut. We also have offices in Brooklyn and Coventry, and I work in representing land trusts and landowners and conservation deals. And then I also practice in the areas of estate planning and real estate.
So we had a session on Tuesday, and I think the takeaway from that was that you should be careful to choose the right tool for what you want to protect, and be careful what you wish for, because you might get what you asked for and it might be the wrong tool. There were some cases that people were talking about that were the wrong tool, and then how did we deal with that? Does anyone have a question to start with, or should we just sort of blather on? Okay, I guess we're at the blathering stage until people work up their courage. So some of the wrong tools, there was a group, I've forgotten who has a farm and they wish they had a conservation easement instead because they really don't want to run a farm. Now, some land trusts do run farms very successfully, but it takes a lot of effort. So that's something to consider when you're doing deals. I've had conservation easements that were too restrictive. In the past, we had a lot of farms that were protected with conservation easements that didn't allow structures. So there was no place to put the cardboard cows because that's all you could have was cardboard cows. There's no barns, and there was no place allowed to sell your produce. So you need to put flexibility into your documents, but you also need enforceability in your documents. So it's this kind of trade-off. You don't want things so loosey-goosey that nobody can say you were doing something you shouldn't do. I think all of us have set-asides we wish we didn't have because of all the enforcement problems with the neighbors. And I'm not saying that you shouldn't take these things, but you should be careful. We were talking earlier about swap land and selling land that you already have. Maybe Amy, you could address that a little bit.
Yeah, okay. Rick just posted a question, but I will say there was two. I was talking to Linda and Ayla about some of the topics that I seem to get, or questions that that are recurring for me. And they both are around land trusts or protected land being conveyed. And the first is whether land trusts should convey their land. And the second one is what happens when a municipality attempts to convert land from an open space to another use. So certainly we can talk about that if you have questions about that. But they do, I get those questions, I feel like weekly, those come in from one category or another. So that's another, we're certainly prepared to talk about that. But Rick had a question, brave soul, he's the first one with a question. Let's see.
Private benefit, right? Why don't you read it?
Yeah, I'm already talking, Rebecca, I'll do it. How does a land trust determine if a private benefit to a former owner falls within the permissible or insignificant area followed by the IRS, but not defined by the IRS? Examples: a former owner wants permission to take out 2 cords of firewood each year, seems relatively minor. A former owner wants to hay a field for 15 years, not as minor as the above example, but relatively minor given the size of the preserve. He would be doing the land trust a favor, as the land trust wouldn't have to pay to have the field mowed.
Well, the threshold thing you have to ask first is, do you consider this person an insider? If he made a donation, that might make him an insider, but he's not on the board. If somebody is an insider, you're not supposed to give them any benefit. If they're not an insider, then you can give an insignificant. It's incidental benefit. Insignificant's not really the right word. It's incidental to the greater good. So if you want your field mowed and you would have to pay someone to mow your field, then it's to the land trust's benefit to allow this person to mow the field, and their benefit, I would say, is incidental to that greater good. Also, if you're trying to promote grassland habitat, and you don't want this to grow up to trees because we don't have as much grassland habitat as we want, then that's another reason this benefit would be incidental to the greater good, and would be allowed. On most of these questions, my answer is to document it. Just document your thought process and why you did what you did. Don't try and hide that you're doing it. Go through your thought process of why this is a reasonable course. The thing about land trusts is they're charities, and charities are supposed to operate for public benefit. That is your mission. You're not supposed to act for private benefit. So you need to explain why doing this, allowing this, is for the public benefit, not for a private benefit. If it's really de minimis, it's really de minimis. I don't know. What do you think, Ayla?
Yeah, I mean, I agree with what Linda's saying. I'm sorry, you might hear my children yelling in the background. I just heard a loud one. They're having dinner in the other room, so I
future conservationists.
Yes, that's right. That's right. I agree. You know, I mean, it really, unfortunately, it's a vague area where there's, you know, a term permissible and a term insignificant where we don't have definitions. But I completely agree with Linda that basically the key is have a conversation around it and find out, you know, are you doing some kind of private benefit to this person, or is there some kind of conservation related justification, or is there some kind of, you know, benefit that you, the land trust, are getting from it? And if you can find a way to justify it and document that justification in a manner that everyone feels comfortable that we're talking about something that's not, you know, significant, then I'd feel comfortable with it. But it's going to be case by case and evaluate it based on, you know, all the facts that pertain.
And realize that there's a PR issue out there. There might be somebody who says, well, you let him, it's two-sided PR issue. You know, well, they're letting him get away with something special, which doesn't do your reputation any good. You know, he's one of those insiders, and he gets away with, they're not acting for the public good. And the other side of that, which I've totally forgotten, was also the PR issue of, is there somebody else who wants to do that, who would pay you to do that, whatever, along those lines. So I think the firewood is maybe so de minimis. Well, 2 cords is not insignificant. I mean, that's noticeable.
Yeah, I agree with you, Linda. I'd be more worried about the firewood than I would about the mowing, because the land trust, you're saying you have to pay to have it mowed. So they're basically saving you money, right? But the 2 cords of firewood, I mean, that's like what, $500 for 2 cords of firewood? So, you know, you have to decide whether or not you think that's de minimis or not. It might not be.
Can I say something? I'm a certified forester. The average price in the woods for a cord of firewood is something on the order of $5 in Connecticut, or 10. If it's loaded on a truck in log form and you have a log truck and can get it out, suddenly it has value. But the fact is that standing wood in a woods is of minimal value, especially low-grade wood. And in fact, with the present problems with with the emerald ash borer and a bunch of other things, you may find that getting rid of trees adjacent to trails that ultimately will pose a hazard is a desirable thing. And I would think that if a competent person went out and looked at this specific site, they probably could find trees that will pose a hazard, identify them, document them, and say, we would be delighted to be rid of these trees if you wish to cut them. That's another possibility.
Yeah, if it's hazard trees, I don't see, that I would think is, again, a service. If it's a property where there's public access to, and you're removing hazard trees for firewood, then that's serving the land trust. But I would still be a little worried if you're not sort of defining what kinds of trees we're talking about. I might be a little worried.
Agreed.
It's document that thought process. You know, they're taking out hazard trees, and we can let them take out some other trees to, you know, because they're doing us a service. Or on the other hand, you might have some environmentalists who say standing dead wood is really good for the forest. So you have to document how you make that decision. But very good point, you know, that the dollar value of this stuff on the ground, because somebody's got to do all the work to cut it up and turn it into firewood, you know, it is very small, and the service to the land trust maybe is larger. But again, you gotta just make your decisions. And the interesting thing is that if well, directors are generally protected for making reasoned decisions. So they should show that their decision is reasoned. It can be totally wrong, but as long as it's reasoned, you are generally protected, at least from liability in those issues. So you want to show that thought process. Interestingly, people who don't show up to board meetings, who are directors, are more liable than people who show up and make the wrong decision because they weren't being responsible and didn't show up. There was another question, or no, or?
But that's also another good little side plug to always make sure you have your liability insurance for directors and officers. It just, remember, you know, you may be doing a volunteer service, but just remember you are liable. So make sure your land trust has that liability insurance.
Madeline just put in the chat that with the hay example, if you're keeping it mowed for grassland habitat, just to make sure that the timing is right, that's not the normal haying time, because you have to worry about the fledglings and everything. So
that's an excellent point. So I completely agree with Madeline. Make sure that you are, you know, talking to somebody who has the conservation background to know what seasons should be completely prohibited, right? So nesting season and, you know, whatever other seasons, but that's an excellent point.
Mm-hmm. And Connie, I see you have your hand up.
Yeah, hi, can you hear now? I had troubles getting connected. Can you? Okay, good. And I just, before we completely drop that, the whole time, Linda, I was thinking of one of my favorite take homes from you, which is about the grandma test, and that's like, no matter what the law might say, if, the public perception, if this isn't something that you could explain and would make sense to your grandma, then, you need to give it some extra scrutiny. So, I think that with the
along with the smell test.
Right, but isn't it? Oh, so what's the grandma test?
It was the smell test and the grandma test. The smell test is, and the grandma test is that it's not so complicated that your grandmother couldn't understand it and believe it. So yeah, I think there was another test there too. Can't remember it.
I was feeling accountable to my grandma. My question has to do with title. And my land trust, the Kent Land Trust, is going through accreditation renewal right now. And we had an EFI related to title because when we first went through
EFI?
accreditation, an expectation for improvement.
Oh, okay.
Because when we first went through accreditation, we had to explain to the Accreditation Commission that the standard look-back period was 40 years. Now, this is not, I get very confused with title searches and title investigation, and this is in connection with an easement. We submitted a certificate of title issued by our attorney saying that she had examined the records, and her certificate of title goes back to the last transfer for that landowner. So basically the certificate of title says I examined between last November, which is when we got the easement, and the year 2000, which is when this landowner acquired title to the property. And I think that the justification of writing it that way is that she also examined that landowner had clear title when he acquired the property. I don't know if she's not able to write the certificate of title for a longer look back period, but the Accreditation Commission is now asking us why that's sufficient. And is my explanation just that the title search went back longer than 2000, and is not related to the certificate of title? Help me understand what it is that I need to do to satisfy the Accreditation Commission that we've actually looked back 40 years.
Ayla, you're the due diligence person, so I'll let you go for this.
Yeah, so with title searches, there's sort of two different kinds. There is a full title search, which does the 40-year look back, and then there's a current owner search, which just basically goes back through the current owner's history and examines title during that time period. I always recommend the 40-year search because you want to know what's happened before, because just because someone bought, property and since they bought it moving forward, title's clean, you don't know before that. But it's possible what your searcher did. Sometimes they may have back title, which means that when they did the search on the current owner, they had already done a search before, so they had back title, so they only had to bring it up. So if that's the case, then you can certainly justify that you've met the 40-year period because your searcher had back title. So I'm not sure, does it sound like they had back title or does it sound like they just did a current owner?
I'm remembering back title, and definitely with fee property title searches, I personally examine all of the deeds beforehand too. So I'm pretty confident that that is our practice. And it may just be that she wrote the certificate of title a certain way. Mm-hmm. Would you write a certificate? You can't give a certificate of title, or can you, for years before the current owner? I don't understand that part.
You can give, well, go ahead, Ayla.
Yeah, no, go ahead, Linda.
Yeah, well, first I wanted to explain in case people don't understand. Good title, marketable record title, you go back 40 years to a root of title. So you have to find a deed that's at least 40 years old. So it's not like you go back 40 years and stop. You go back to at least 40 years to somebody who got the property. And then you go forward and see what encumbrances are on the property, and your certificate of title would refer to any encumbrances that are still outstanding. And there may be one from 30 years ago that never got resolved, or there might be a right of way or a right to a well, or somebody owed money. And there are some other statutes about when those things expire. But yes, you can give a certificate of title going back 40 years to a root of title.
I'm sorry, I don't mean to interrupt, but let me just stop you there, because I just looked at the certificate of title, and the certificate of title makes references to encumbrances, if any, as described on Schedule A. So wouldn't that certificate of title include any encumbrances that were still on the property? I mean, isn't that a way of saying, you know, that if these aren't listed in Schedule A, I mean, it's basically like, you know.
But if they just did a current owner, though, something could pop up that's not on the current owner search. I've made the mistake of doing just a current owner search and then finding out about something that was on the land records before. And so I don't trust current owner searches at all.
It may be, though, that the Accreditation Commission is confused, because the certificate of title would say that I've examined the land records and Jane Doe is the owner, free and clear for all encumbrances except these. And that doesn't mean that they didn't go back 40 years. That means that's who owns it now.
The certificate even, you know, the Schedule A even says being the same premises as conveyed by deed, and then makes reference to these older deeds. So, and I'm switching back and forth because I don't want to spend too much, you know, I don't want to be pulled away from this Zoom, but, you know, it may well be that reference is made in the certificate of title to, you know, to records dating back, you know, to that ownership transfer 40 years or prior.
Your certificate may well be a 40-year certificate, because you don't say I went back 40 years. You say title is clear except for these things, and title is clear because you went back 40 years and checked it. And that's what the statute.
This is really helpful. I feel like I'm better equipped to examine this certificate and maybe put forth an answer to the Accreditation Commission.
Could you just reach out to the attorney who prepared it for you too? Would she be able to, he or she be able to help?
Yeah.
Yeah, she might be able to just give you a blurb saying, I went back 40 years per the Marketable Record Title Act on this. And just make them, because other states have plat recordings. They don't always have the same kind of recording system we have. So things are recorded by property, by the property, not by the owner. So out west, they don't have a clue what we're talking about.
I don't want to complicate things, but we a few years ago took a property that was had been in a family for more than 125 years, and it was eventually it became an undivided interest. We actually found in the title search with doing someone's will that there was a direction that was not in the deed that alerted us to the fact that some of this land that was in the family, they were leasing to a church. And it went on and on and on for many, many years. And then the family, of course, after we found that, and before they transferred the property to us, released that portion of the land to the church. So it's an unusual circumstance, but sometimes when land is in families for many generations, it might service us to look at the wills also. I don't know if anybody's had that circumstance, but.
Well, a title search only tells you what's on the land records. It doesn't, they usually disclaim anything about surveys. You know, there could be deals that are just not recorded. And that's one of the reasons why title insurance is a good idea in a lot of cases, because there's stuff that you just can't find. It's kind of like a building inspector can only see what's on the outside of the walls, that can't see what's inside the walls. Lots of disclaimers. Do we have any other questions? Well, there must be some good ones out there.
We just got another one from Rick. Do utility right-of-ways ever expire? And in parentheses, he put, thinking of what is apparently an abandoned telephone ROW with no wires or poles standing.
I guess my first question would be, have you ever looked at the language of the utility easement? Do you have language for it? Because sometimes they'll say in there the term of years that they're for. So it could be a simple answer of just looking to the easement, seeing if it has a term of years. But in most instances, these telephone companies are not wanting, limited easements. They want them forever. So even if it's, not currently used, it's still something that could spring to life. What do you think, Linda?
Well, number one, the 40-year marketable record title is you have to have something in the 40 years, otherwise stuff back there expires. But any deed that refers to that easement sort of revives it. So and it's not that nothing over 40 years old expires. And I think there might even be an exemption for utility easements from marketable record title, but I'm not sure. I would assume that they do not expire. I'm just not sure why, because they're mostly older. And you do, there's sort of it's kind of also a contractual agreement with the company, and the company still probably exists. And if they're visible on the land, then there's knowledge of it. So that's another reason it wouldn't expire. You have to not know it's there. Not sure.
Yeah, I think you're stuck with it.
And I think there's a distinction between exploration and abandonment too. And I don't know the answer, but I think that there might be something in the statutes about that.
With most abandonment of a right-of-way requires an affirmative act. It's unlike land, well, even land, but easements, they don't expire. You can't get adverse possession of them unless there's sort of an affirmative act, because easements and right-of-ways are kind of a right to do something, but you're not required to occupy the land and own it the same way. So they're less likely to be formally abandoned.
I have a question about easements. If a homeowner about 25 years ago put an easement on his property and it was extremely strict, and moving forward into this century, is there any way to, and he took all of the benefits that allowed, is there any way to lighten those easements today to allow some sort of not even a building, but even a patio? Because the way it's written now, he can't even have a patio in the backyard. So it has transferred to another property owner. So they're asking if there's any way to lighten the load and the responsibility, and if they could at least get a patio in the back. And there's no envelope around this house either. It goes right to the foundation. The easement starts at the foundation of the house.
So is there a reason the land trust would want to agree to this?
We don't. That's why I'm asking if there's any way we could lighten it, because he would like to do something, and the trust that has it would like to pass it to us, but we don't want to take it like that. So I was just wondering if there was any way to lighten the load so that we could take it.
Well, I think you have to stick with the original intent. I mean, that's the public interest is in what was granted to the public, and the original intent of, I'm assuming it was a donor, is enforceable by the AG. That said, if it's really difficult to enforce, you might be able to get the Attorney General to agree to a modification. If it doesn't substantially change the conservation values, but you have to go down the list of things, amendment kind of requirements. So it has to be at least neutral to the conservation values, can't give a private benefit. Remember, we were talking about private benefit. So you're giving a private benefit if you could expand the size of the house. But on the other hand, you don't want to be going there all the time and tell him to, get his lawn chairs off the lawn. Sounds like something you shouldn't take because it's a problem and that's why somebody wants to get rid of it.
Yeah, but we haven't taken it yet. And,
But we do some modifications, but usually we try to find a way to make the whole thing better from a conservation point of view so that the scales tip in your favor. So you have a better easement that's enforceable, that has all the enforcement stuff that we never used to put in there, that has the up-to-date language. But you can't give a big benefit to somebody. If they have any other land they could protect, you can add that into the mix. But in the end, it's got to be a win for conservation, not for this guy.
I think that this situation does highlight, though, the need when you're drafting easements to think about perhaps having a small exclusion area around a house, or, just thinking about, when you're in that initial easement phase, thinking about, this is, a house that someone else is going to buy in the future. And, can you allow a small building envelope, where people can still put their, steps or their little chicken coop or something. It's important to think about that when you're in that initial drafting phase. I had a client who wanted to buy a property that was subject to a conservation easement, but unfortunately, when they put the easement in play, there was no building envelope. It covered everything, and the original owners had never finished building steps off the back of their house. So they had sliding doors that opened, but there were no steps. And under the easement terms, you were prohibited from even building steps to complete that step down. So it's just a good sort of cautionary tale to remember when you're drafting these things. Think about maybe a small building envelope so that, basic, I'm not talking about building swimming pools that you might not want, but so basic things can still be achieved.
That's exactly right on point. And this happened, a number of years ago, and our mindsets in the land trust community have changed, and we do understand the importance of an envelope, and we try to tell our clients that how important that is. The other thing that's very difficult that I repeatedly come across is these deals take a long time to happen, and the families get attached to you as we get attached to them. And when it comes time to actually do the deal, you can't stress enough how important it is for them to get their own attorney for representation. And they just don't seem to understand that it's in their best interest and our best interest that they have that, because they think that, you're friends, and because many times that is the case after, 6 years of trying to do something. And in this particular case, he went ahead, and it wasn't with us, went ahead without an attorney. And he wanted to preserve this land, but he did not put an envelope around it. And when he was doing this, we were not as far educated as we are today in putting envelopes around properties. and this is the result. Had a lot of trouble selling his house. It took close to 3 years to sell his house, and now the current owners are still looking for a little relief. So that's why I asked the question, because they don't have, they don't need steps at the back door, but it's very similar to that. They can't put a little patio back there. They can't do anything because the easement starts at the foundation.
And your comment about how difficult it is for the landowner to sell a house, right? Like 3 years, you said.
Yes.
So that also gives bad reputations to these easements, right? And that's not what we want. We want people to do these things. We don't want them to get bad reputations. So unfortunately, we have these old ones, right? These seem to always be the problem ones, is it's the really old ones before we had new as much as we do now. So those ones are the problematic ones. But happily, we've, learned from the older ones, and now hopefully we're not making the same mistakes. We're just making different mistakes now.
And we want to be a good neighbor too. We don't want to get a reputation as being a bully and trying to enforce regulations that are just not livable, or able to live with. So
there might be some other kinds of restrictions you could put on the property that would kind of offset any benefit to him. I don't know how big the property is, but that you could put in forest management language or something that protects your conservation values more, and use that as a reason to give them just a little bit of relief, and as well as just your monitoring and management. It makes your administration of the easement easier. And updating the format, but you definitely have to get the Attorney General on board with whatever you're doing.
okay, thank you.
We do have I know, Anne, your hand has been up for a little bit, so I wanted to make sure we got a chance to pop over to you.
Thank you. We kind of have a nightmare easement as well, unfortunately, and this was accepted as an access easement. So we have a thin strip of land that was accepted as an access easement to an existing preserve. And the current property owner is not happy with the fact that the public gets to walk on his land to access the preserve, and he's done everything possible to kind of make our lives a nightmare. He's built a very large building that drains off onto the access easement, so it's very muddy. He's erected a fence that partially blocks the access easement, and we have not been able to speak directly to him. He only corresponds with us via his corporate attorneys out of New York. And most recently, we reached out and said, since he has purchased almost all the land surrounding our preserve, we suggested perhaps he would like to give us an alternate easement area. So we would keep our existing one and just kind of let it, go wild, but have it in place, and then use an access easement that he doesn't have to look at. And we thought perhaps it'd be safer for the public, because the current one is you can basically go down to your knees walking through that. It's so muddy, and you can imagine what it's like now. So recently, his attorneys have reached out to us and said, before the lawyers get involved, can we have a chat next week? And we're represented by counsel, and so I was kind of like, well, you guys are counsel, and it just seems a little awkward. What are the?
It's not only awkward; it's unethical.
Yeah.
Well, thank you. That was my understanding, that you're not, if someone's represented by counsel, you're not supposed to go around that.
The lawyers got to talk to the lawyers. You guys can go behind us all you want.
Yeah.
And sometimes that can be very useful. But the lawyers, when they know that there's a lawyer involved on the other side, they have to talk to the lawyer.
Okay. Thank you.
But that, so he bought the property and he knew about the easement when he bought the property. So, it's buyer beware. I'm sorry you're in that situation, because that's, why people do title searches and do their due diligences, so that they know. So good luck.
Yeah, it's kind of a Hatfield and McCoy situation with the preserve gifter, so that's the issue.
Oh, even better.
Yeah.
Good luck.
We have a really strong encroachment statute. Don't let them get away with blocking the easement. That's just not acceptable.
Do you happen to know what that citation is for the encroachment statute?
52-360A.
Thank you.
And Keith Ainsworth is the expert on using that to great effect.
Thank you.
Ayla and I are really transaction people. We're not as much the adversarial litigators. We're the good guys. He's the bad.
Thank you.
He loves it. We like to avoid controversy. He loves it. But
that was my thought, though, with these last two examples, too, is that we try to be reasonable, but we're going to really erode faith in conservation easements if we are crumbling to, successor landowners. Successor landowners need to be held, they knew when they bought the property what it was, and maybe they didn't do their own due diligence, but we can't be too, I know it's case by case, but it just seems to me like we really should watch that.
Yeah, no, you really do, because people will try to bully. I mean, it's a fact, right? And so, like land trusts are viewed as the do-gooders and probably looked at maybe as like they could be the pushover, right? And so it is a fine line where you want to have a good relationship, but at some point, if people are pushing and violating the terms, you have that right. You worked to get that easement there so that your preserve was accessible, and you have the right to maintain that and have the landowner carry their obligations. So I think that's a very good point, that it's important that you defend what you've worked hard for.
it's your responsibility. It's not just your right, it's your responsibility. But we have really great statutes here. Land trusts should not be frightened of standing up for their rights. The law really does favor us here. You don't want to be unreasonable because you don't want to get a reputation for being unreasonable. However, winning a good lawsuit will back off a lot of potential encroachers. And in some ways it make you more respected too, because people will trust their property to you.
There's a couple of outside issues too. I just don't want to take up too much of the time, but it's complicated. But thank you. I appreciate the link.
And just one more thing before we move on, back to what Linda was saying in the beginning, is documentation, right? So you should be documenting everything. Take pictures of stuff you see when they're violating anything. Take notes about when you have meetings, have a witness present, things like that. Document everything, because in the event this ever does have to, go forward to something more litigious, it's helpful to have that in place.
And
we have a binder.
Is this a right of way you own? Or is
it's an easement, and it's a very poorly written easement, I have to say.
God save me from those 10-foot easements.
I just wanted to jump in. I see Priscilla's hand up, and Priscilla, I won't take much time, but I think it's an interesting what you said, Anne, though, about his offer to allow you another, another access. And I don't know if he meant granting but other alternative access, because I did see Rick had written in the chat that he also has, their land trust is dealing with issues of blocked or interference with access. And I actually think, it's unusual then. That I don't think is that unusual. I mean, you hear about that. But what I think is unusual is that this landowner has offered you an alternative access.
He didn't. We suggested it.
Oh, you suggested that.
Yeah, and he hasn't responded at all.
Okay, that makes more sense to me, because I thought he's being very reasonable on the other hand. Okay, got it.
Yeah.
Priscilla, I'm sorry, I didn't mean to jump in, but I thought that was an interesting and erroneous, interpretation on my part.
Quite all right. I just was interpreting or questioning, if you have an easement that's the right-of-way easement, does that easement imply that you have to keep it as an accessible right-of-way?
You can't block it.
So but letting water drain into it so that you can't walk through it count as blocking?
It's a good question. That's definitely gray. I mean, it depends. I would think personally that it depends a little bit on, is he creating the situation that's resulting in the drainage, or is it a natural drainage? If it's a natural drainage, then, that's been there since, the property's been owned. I don't think you have as strong of an argument. But if he's creating the water flow purposefully, then that's, the intent there is to disrupt the easement and interfere with the purpose of the easement. And again, the language of the easement is going to come into play with any easement. So, is this, what is the access? Is it the right to pass and repass by foot? What exactly does it say? So you're going to want to look at that too.
Okay. I was just curious.
Yeah, and easements, right of ways may not be conservation easements. You'd have to kind of look at them closely. So you may have more options than you would for a conservation easement if it's really not.
It's strictly access.
So that's kind of a gray area, let's put it that way. It might fit under the statute, but it might not. Which could be to your benefit, because then you might be able to swap it. As long as it's not, because you couldn't swap a conservation easement or that probate court approval, but you might be able to do something like that with an access easement. Check with the AG though. It's always good to have, let them have your back, and you it's CYA, the AG said it was okay, so we're good. Yeah.
Thank you.
And I just wanted to quickly note, I did put a link in the chat towards our resources that Keith has actually compiled for us for the list of Connecticut general statutes that pertain to encroachments, and then of course a whole bunch of others that pertain to land conservation, and those will link out to the state's website for that too.
He stole my list. He did improve on it, but he stole my list.
I'm sorry, my mistake, Linda.
No, his is an improved version. Yep. Do we have other questions? I thought if nobody had questions, I'd just kind of walk through some of the stuff that the upper level question trying times seminar at the national level has been going through. One of those is that approval rights, easements that have, what do they call it? Well, an automatic approval. If you don't respond, those are not acceptable to the IRS. So we used to sometimes have easements that said, if you ask the land trust for approval to do something and they don't respond in 60 days, it's deemed approved. You can't have a deductible easement that says that, because things could slip under the rug. That shouldn't be allowed. You can do a deemed denial or something similar, but you can't have a deemed approval. We now have a case that says that in your extinguishment clause, your proceeds clause in an easement, I don't know if you guys know this stuff, it might be, you can't allow the division of proceeds. So I'll start from the beginning. When property is condemned or taken for eminent domain, the proceeds are split up between the easement holder and the owner. Your proceeds clause can't make an allowance for the fact that they built a house on the property or whatever, because that's not what the regulation says. So we've taken that out of our easements. And the model easement has dealt with all these things. So you can be assured if you use the Connecticut model easement, we've made sure that it's up to snuff on these IRS issues. Let's see.
And I just have a question related to the model while you're looking for our next topic. I'm just curious if any of you out there have used it. Have any of you used the Connecticut model easement? Connie has. Anybody else use the model easement that we developed for any land deals?
Yes, we have.
Madeline has. Good to know. Good to know. Okay.
Yeah, and there's a pretty good array of options now that goes with it. And we have a forever wild easement. And the agricultural easement's been updated with the boilerplate that is in the model easement so that they match better. We were afraid people would use some of the old boilerplate. So that's been updated. So this, and we of course have this big commentary that goes into all the reasons why we have all that stuff in the easements. So there's a lot of resources, and they're all on the CLCC website. So you can just pull them off there. If you need a Word copy, you can contact us, and we can provide that to you. Let's see, what else? So Amy, you were going to talk about swapping. We started.
And if anybody's, I get a lot of questions. They come either through the listserv, the Connecticut Land Trust listserv, or to me directly. And many of them relate to, can my land trust sell or give away or swap a piece of our land? And as I was talking to Ayla and Linda before, I mean, our default answer has always been, well, you need to run those, generally, you need to run those by the AG's office. And there's reasons for that. The first, of course, is that donor intent is very important. Unless, and we were talking about this, unless a landowner or unless a donor of property or somebody who sold you the property writes you this letter that says, I'm giving you this property for the express purpose of selling it so that you can then use the revenue to purchase conservation lands. And there are cases like that. I know of a number of them where land trusts have absolutely received property for the very purpose of selling it and using it. It's an asset, you know, it's a donatable asset, and landowners have done it. But in a case where that's not, that's certainly, or it's not the case and land has been donated for conservation purposes, the AG's office needs to be alerted to it, and really you need to seek the permission because of the charitable trust doctrine and donative intent. And there's a whole division at our AG's office, which you probably all know of, that deals with this stuff. So that's one of the ones that I get, one of the questions that I get quite often. And the other is my municipality is taking a park and they want to build, you know, a school on it. Can they do that? And the answer usually is, it depends. But I was looking back at a presentation that I did for Kakiwick back in 2018 and did some research, and attorney Mark Brantz, who many of you know, he's a corporation counsel, you know, a town attorney, and does a lot of this stuff. And we went over this stuff together, and that if a park has been expressly dedicated and there is a statute that says how you dedicate a park, then according to the AG's office, unless there's something in there that offers an out for the town somehow in the language, they can't convert it to another use. And it happens a lot. Why towns often win is because it's generally not a clear-cut case, and that there is some wiggle room in terms of the dedication, which can, by the way, be by implication, that land can just, by virtue of its use over years and years and years as a park, be deemed to be impliedly dedicated, in which case the AG's office could weigh in there and they have discretion to enforce. So that's another one, and there are statutes relevant to that. I'm happy to share those. And then lastly, and not very often, I'll get the question about, well, sorry, the dog. Hey. Often I will get the question of, well, gee, the town, you know, has a land that they purchased in part with an OSWA grant, an open space and watershed land acquisition grant. There's a deep easement on there. Can they now get rid of it? And there is a statute that covers that, and towns can. There is a process by which they would have to go through public hearing, et cetera, public notice, but they can only convey it to a town for like uses. So it's not like they can just sell it and use it for something else when a deep easement is on there. But it is a little bit of a, you know, one of those like, wow, really? And there is a statute that covers that. So happy to share those citations if you're interested in them.
I just wanted to point out there's a little activity in the chat. Oh, and a question. Rob Beach from Joshua's Trust mentioned that they just did a swap that Ayla worked on with the AG. And Rick Newton noted that a school swap deal happened in Groton recently, or a few years ago. I see Valerie, you asked regarding swap or trade lands, don't we need to check our incorporation papers and/or bylaws first?
Well, you certainly could have something in your bylaws or incorporation papers that says if once you get land, you can never sell it. But that's pretty rare. I do know of at least one land trust that has some language like that. Yeah, you should know what is in your documents, but no matter what you do, you should be operating in accordance with your mission and your purpose. You know, if you're operating in a way that's not your fiduciary duty to conserve natural lands, you shouldn't be doing it.
Yeah, and I want to add to that also, Linda, I'm glad you mentioned that, because we were chatting about this before, of course, there is the PR issue. Even if it is airtight and you have the right to go ahead and sell the land, you know, there are PR issues. And I know of a land trust that wisely got in front of that because they had been burned in the past, where people were accusing them of gee, you know, here's a land trust and it's selling land, even though it was documented that that was the reason why. And the next time it happened, they got out right in front. They thanked the donor very publicly for the land, for that express purpose of being able to sell it so that they could raise revenue to purchase conservation land. So there is that PR issue as well.
Yeah, it's something you should add to your due diligence list is if this is going to be swap land, if you don't think you're going to keep it forever, get something from the donor or whoever you get it from saying that that is the intention, is to allow it to be done. Yeah, you want that history in there. It'll make things a lot easier. And I did have a client a number of years ago who would not deal with the local land trust because she had heard that they sold land. I was never able to confirm that they had actually sold land, but she would not deal with them. We actually ended up dealing with the New England Society for the Preservation of whatever, because she would not deal with the local land trust. So that reputation is easily lost. But if you have a piece of paper from the donor saying it's swap land, that helps a lot.
And just going back to the swap conversation, so if there is, you know, a parcel that you're thinking about swapping with for another parcel, and you're seeking that AG approval, you really want to just be thinking about, you know, what conservation purposes and enhancements are being achieved through this process, right? So the AG is going to want to know, are there conservation benefits to this trade? And so you're going to need to be able to document what those are. They're also going to want to look at the appraised value of the parcels being swapped, because that's definitely going to be a factor. Is it similar? Is it off by a landslide? So that's something you're going to need to prepare. If it is different, you're going to need to be able to defend why, you know, the conservation purposes sort of outweigh that financial difference there. So if there is, you know, a swap you're contemplating, it's helpful to, again, document and prepare your, you know, list of conservation benefits that are achieved through the swap.
Yeah, I know of one land trust that got a donation of land, a house with 20 acres. They sold the house, kept the 20 acres, used the money from the house to fund a war chest to buy other properties. So it was a great deal, but it was all laid out. This actually came in by will, and it was all laid out in the will that this was the intent of the donor, and they have not suffered PR problems because of it. Some other questions? So one of the other things that came up in the Trying Times seminar last year was talking about baselines. And saying that it's really important that your baseline, and if you're doing an easement, standards and practices, IRS, require that there be baseline documentation showing the condition of the property at the time of the gift. And there's multiple purposes to that. One is to say that, you know, if Dunkin' Donuts shows up on the property, it wasn't there at the time of the gift. So we know that this person is the person who did this encroachment. And the other is to tell the IRS if it's a deductible easement, or anyone who's interpreting this easement in the future, why you did it. It becomes the institutional memory of what's important about this property. There's things in the easement. We try to put those conservation values, why we're trying to protect the property in the easement itself, but the baseline gives you a lot more information. It can give you pictures and history. And it tells all the wonderful qualities of the property. So the IRS would understand why it does meet the IRS requirements, because the IRS has requirements for the conservation values. You can't just put an easement on a piece of property preventing houses and think that that's deductible. It's not. It's about conservation. So you need the baseline and the recitals in your easement to be in lockstep and to supplement each other. And that's important. A lot of our older baselines are really these dry recitals that don't really give a judge a lot to hang their hat on. I always tell my baseline preparers, try and find me some really great critters, because judges love critters. You know, the judges, we have cases where there were bald eagles there once 10 years ago and slam dunk. You know, bears are popular. Raccoons are not popular. Those are not special wildlife, but find some rare and endangered species. And we have lots of them in Connecticut. It's really helpful when you go to a judge and want to enforce this. And it's really helpful when you some IRS agent in the middle of a city opens this thing up and he sees these pictures of this beautiful property and it recites the critters on it. And it's like, oh yeah, this is worth the public money that's going to be deducted. Let's see. What else can we talk about?
Any other questions from all of you out there before we get to the end and then wind up going over because we spend the last 3 minutes on a question? Any questions now before we have some time here? Before we end? No?
No thorny issues out there? You must have problems.
That's what I was waiting to one of those tough ones.
I had I guess it's war story time. I had a case where property was subject to easements and restrictions and was held by a conservation entity, and they were going to sell it. And they were told that if they did sell it, the money had to stay with the property. So they had to convey it to another conservation entity. But if they tried to sell it for money to the conservation entity, the money would have to go with the property as an endowment. So that didn't work. So they're giving it away.
Well, I have a war story of when I was practicing and I represented a seller, and this goes to the importance of title searches when you are a buyer. And the land trust, this was a 7-year deal too, and the land trust waited to do the title search and then told us probably at least halfway in that not only didn't my client own the entire piece, but there was a lis pendens, which is a notice of litigation on the land records with respect to a divorce settlement that he had never paid. And so that at that point, we were probably 4 years in, and it took 7 years to close that deal, partly because we had to clear title. Oh, and there was a mortgage that needed to be subordinated and couldn't get it to be subordinated, things like that. So that title search early on is super important.
Rob, I see your hand up. You have a question?
Or a war
Yeah.
story?
Well, I have a question that's kind of a hangover from Tuesday night, which is if you have the conservation easement on a property and then later get the fee, is there any kind of obligation to have someone else monitor and enforce the conservation easement? And it's always struck me that if you're a purist, you really should be, because otherwise you're enforcing the restrictions on yourself. But for practical concerns, at least in some cases, it would seem a little unrealistic. So I'm wondering what the experience with people is in that regard.
Yeah, I think you've hit the nail on the head. Years ago, we weren't even sure you could hold the fee if you had the easement, whether you had to divide them up. We now are pretty well established in Connecticut, at least, as I said on Tuesday, that there's a public interest in that conservation easement, in the restrictions in it. So you don't ever have complete merger where the land trust is not obligated to fulfill its obligations under the easement. So, but you still have the fox guarding the hen house problem, that you're guarding yourself. And so, yeah, it's not optimum for you to be guarding yourself. But realistically, in order to get another entity to hold this easement, you're going to have to pay them money. You know, if the Connecticut Farmland Trust holds an easement on property that a land trust has, they expect an endowment. They're very reasonable on their endowments, but they still expect an endowment because they have to send out paid staff to monitor this property for all of eternity. And there isn't always an entity that's willing to even hold an easement. At one point, we thought maybe, you know, we'll have the next town over, we'll hold their easements and they'll hold ours. And, you know, that would also be a protection against creditors coming in and, you know, trying to get a hold of our property. But nobody wants to be, they have to insure this, they have to monitor it. It's expensive. So it's become the default that land trusts do hold the fee and the easement and don't do anything about it. In the model easement, which the extinguishments section and some of the, and the merger sections, actually the whole thing was checked over by Stefan Nagel, who is a nationally known conservation easement attorney. And the language was, if there was going to be merger, you do have to make sure that merger doesn't happen, either by giving the fee or the easement away and separating it. But we don't have merger in this state, so I think you're okay. And just fulfill your fiduciary duty to follow the restrictions in the easement and follow your mission. And I trust land trusts more than I probably should, but.
Right, well, practically, I don't think it is a problem. It's the theory that I would worry about.
Well, the theory is that it never merges, so.
Oh, I know that.
Common law was it would merge and these
Right.
would actually go away. The easement would no longer exist. You would own all the bundle of sticks, and therefore those you had no restrictions. But that doesn't happen now, and the Attorney General can at least enforce the public's interest in the easement. So there is an enforcement entity out there if they have the will and the knowledge, if they know that there's a violation. And of course, there's probably all the public watching you and making sure that you don't do anything that they don't want you to do.
Valerie did, oh, never mind. I wanted to make sure that was clarified for you, Valerie. So glad it was. Priscilla, I see your hand up. Feel free to unmute.
Just a question, in that case where the land trust has the easement on their own property, do they need to go through the process of filing a yearly monitoring report on their own property so they have that as a legal reference?
That's a great question. Oh, Connie.
Just going to say we have Connie here.
Connie is the accreditation expert. So what do you think?
Well, for accreditation, I would say yes, fill out the monitoring form, and you're there anyway monitoring. And actually, you know, as far as the lingering, you know, small risk that Robert is talking about, that, you know, the land trust might violate the easement, maybe even unintentionally, I think it makes sense in some ways to be filling out the forms from, like, first the person who is checking their trails and all of that, and then maybe from the perspective of the person who's making sure that all the terms in the easement are followed. Outside of accreditation, I don't know that I would say the same thing, although, you know, it's probably your obligation to the IRS to monitor. So I think that in some ways the accreditation standard, that it be at least annually, is, you know, I think it's reasonable, but I don't think that's not law. So, you know, so my answer for you is I think you should do it.
I think as a follow-up to that, Rick had asked in the chat, and do they have to buy Terrafirma Insurance?
Well, I have the answer to that one, Rick, and you would not need Terrafirma Insurance, but if you were buying it for your other easements, you'd have to buy it because it's an easement. So you have to either buy, you know, all your easements and or all your fees or all of each. You can't pick and choose. So,
I see there's a question about from Valerie.
I think she
She's
asked, and then
wondering.
she asked, and then she said you answered it about
Oh, okay.
extinguish the easement.
Okay, got it.
I knew this would happen. We're a minute over time because we always have those last minute questions. But that makes me happy to know that we filled the whole. I wasn't sure, you know, I thought, are we going to have enough questions? This was a little bit of an experiment. When we do this at our face-to-face conference, there's always that you're in the room together and you fill up the time with that kind of just in between gab time. But with the Zoom, I wasn't sure how an open Q&A would go, but I'm really pleased that it went as well as it did. And thank you all so much for these great questions. And just being here tonight. Any other words of anything, Rebecca, Linda, and Ayla, as usual? Thank you so much.
Yeah,
thank you for your good work.
Yeah, thank
Rebecca,
you.
anything from your end?
Just keep your eyes peeled for resources. They're going up as fast as we can get them, as well as the recordings for this session and the last session. You know, we have conference coming up around the corner, so keep your eyes open for registration there. And thanks again, Linda and Ayla and Connie, for being part of the Q&A you didn't even realize you'd be a part of. So, but thank you both very much, Linda and Ayla, and enjoy the rest of your night, everyone.
Yep.
Take care.
Bye.
Thanks, everybody.